before me your question, right?
Are you asking me to ask it as in a way of saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Ms. Willis that was not privileged?
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, when again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on 1 second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Ms. Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was a relationship at that point between Ms. Willis and Mr. Wade, for Mr. Wade to be able to bring you to Ms. Willis for the contract? It's not a hard question.
No, I'm just, state that again?
Mr. Wade is the one that basically says to you, go see Ms. Willis about this contract, right? Mm-hmm. That's a yes, correct?
Yep. Yes.
So Mr. Wade had to have some knowledge, you would assume.
Yes.
Right? That you going to Ms. Willis might bring you the contract.
I never went to Ms. Willis. So I stated I never went to Ms. Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to potentially offer you that contract on Ms. Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to. Mr. Bradley?
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
My question is, what was your understanding of the relationship of Mr. Wade and Ms. Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege. Okay.
All right. Mr. Evans is invoked privilege on that question, so Mr. Saylor, I think you need to clarify whether...
Was it a privileged conversation that you had with Mr. Wade that you know about the contract?
Or, it was the relationship was the question you're focused on.
Is the nature... No. I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now, this would have been something that Mr. Wade said, put into your time period, at the time that you were representing Mr. Wade, correct?
Say that again? Absolutely.
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how cannot relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privileged, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right, then he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference, and
When were you told this?
I can't remember the dates of the conference, but it was after. It would have been after the conference.
Okay, well, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at the that is, Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was he had some position with the municipal court.
Yeah. Right now, my only question is time-wise. Assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yes, it would have been before that, yes.
So, what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again?
You don't have to answer the question, Mr. Braley. Next question, Mr. Sedan.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice. So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copy.
Text message? What's that one? Not David.
text message.
You want to get into the content?
I'm going to set up a question.
Okay. So I'm going to have objections.
Of course you're going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. Yeah, approach.
You may, sir.
Look at this text message.
Can I read it first?
Of course, of course. Okay. Kind of hard to reject that, and that's the question. Okay. Then you must be a soothsayer. Mr. Bradley, I showed you 2 text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think so, yes.
Okay. And the text messages would have been between you and Ms. Merchant, correct?
I didn't say, yes, it should be.
Okay. And I've shown the same 2 to prosecution, so we're talking about the same 2. In the text message to Ms. Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct? I haven't asked him anything about what the...
Flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes.
And it's your testimony that the information that you imparted to Ms. Merchant in these 2 text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established.
Well, the question, he didn't get into anything. He just said, are these 2 text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these 2 text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right, and I think
That's what you're going to do.
sure, so I'll sustain that on privilege.
And I'm going to introduce for the record, when we finish these 2 text messages, so that Your Honor has those back there, so that you can...
Sure, what would they be marked as?
What do you have?
I have a whole set. Okay.
I'm going to go ahead and...
The contract.
The new one will be 26.
Once I put a staple in it, I think it'll be Defense Exhibit 26.
All right.
You have to give me a real pen that works.
All right, so this is marked and made part of the record as Defense Exhibit 26, but not necessarily for its...
This is not a
Evidentiary
committed
value.
26. This is for purposes of the court conducting the in-camera review. And put a staple in it here to make sure that you see it. No charge?
Nope, it's free.
All right, Ms. Seda, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know?
He responded by text.
You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but
Okay, I'm going to get it for you because I don't want there to be any assumption. As soon as we have it. Let me show you. This is an email.
Is that what you're...
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
yeah, I see it, the email, yes.
So that's the email that you received. Along with, obviously, the attachment, which is referenced.
Yes.
And then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. Okay, we'll mark this as another exhibit for Your Honor to look at. Since you love my tone, can I have some? Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. What's the court's rule, to ask or not to ask?
We'll take it case by case. I think he's doing all right, so we need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
perfect.
sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Have you, last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee-sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason?
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Ms. Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have
Wait.
anything to do with his conduct?
Oh, wait. So we had a disagreement. Whether the disagreement was, we disagreed, and so we dissolved. I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't. If you define misconduct, I'm telling you, we had a disagreement, and we.
Just tell me what the disagreement was then.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged.
It
Why
is.
is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Ms. Willis.
As it a connection to Ms. Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. You kind of got lost on it.
You asked the question.
It did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I would have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I would have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation that you've made reference to.
And he continued to, yes, and he continued to represent me on the construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Ms. Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sada, I think we've...
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So, I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be that we've already gotten an answer on that, and now we're asking the same question again. Ms. Merchant asked him variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But, Mr. Soto, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking, respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we've talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it and the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to the court before I sit down is, if hypothetically, you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So, again, just to follow through to make sure. So, if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception, and I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadat, that is something that you can, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one I
argument.
gave you,
The Coca-Cola one?
the 1935 case.
The Atlanta Bottling Company? I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court, but we can flesh that out in our research.
I appreciate it. Thank you.
Mr. Stockton.
No question, Judge.
Mr. Durham.
No question, Your Honor.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
No question, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay. Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let me pause you there. Isn't adultery, as a statute, just on its face, been found unconstitutional? You can't actually charge anyone with adultery anymore.
it is still current in the
Then it
state.
can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information both with the original interrogatories that were filed in December of 2021 and frankly with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions, Your Honor.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Sometime frame 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it would be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No, okay, Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it, yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So
well, just give us totally how much money you got for representing Mr. Wade in this, since 2017 or whenever you told us, up until you dropped off the case in 2023.
I don't recall.
Well, the answer would be zero.
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
Yeah, I'm going to object to asking you.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. And I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist. At some point.
I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that, but the questions I've heard so far are more from you were never paid ever, it's from an overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm, and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And are we friends? I mean, we were friends at the time, yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking answer.
All right, I'll answer this one question overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to really talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume you...
Objection, just going back into the privileged communication.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life, about what was going on in your life and what was going on in his life, right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
Again, I'm going to object.
All right, sustain. Next question, Mr. Gillen.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life? That had nothing to do with him asking you legal advice.
Objection, to be more specific.
I think he's just asked whether he socializes outside of legal advice, so I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right, so that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out legal advice, not talking about something that might be personal and confidential. And that's the distinction that I would draw.
I think that's an accurate legal point. However, I think the witness has already been questioned and testified on this point. Next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now,
did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we,
Objection, he's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered in your attorney-client law.
Mr. Gill?
I don't think it's attorney-client. Did they meet together, and when the interrogatory answers were filed, did he file them, and did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content.
Objection.
You had all of that knowledge and information. I'm sorry, let me get my question out
That's what I
before
was trying to
he
say.
objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's, the follow-up question to that is going to be incorporating knowledge learned during communication. So
Oh, no, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay.
It's all
In which,
It does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
okay, I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up in his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant, now...
So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Will there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered under privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you are leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which have been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right, well, thank you, Your Honor. That's all I had.
Thank you, Mr. Gill.
Thank you.
Mr. Kucherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Two brief questions, Your Honor. I think everybody's exhausted with this line of question, right?
You go, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, it would have probably been, well, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier for you.
Okay, all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023, is that true?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man, would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay, so, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in the pleading there's a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
But I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm going to have a minute. My cross-examination might be a long one, so we can go for about an hour and a half. Can I have just a 5-minute break?
Sure. All right, we'll be back in 5.
Yeah.
we're back on the record, and, no, maybe, no, we're not. We can get Mr. Bradley back. While he's coming out, Ms. Merchant, for planning purposes, based on how Mr. Bradley's testimony was presented, do you anticipate calling any further witnesses? All right.
Mr. King, I had a copy of the church speech, but I think he was
Right. We'll handle that with housekeeping at the end.
Okay.
Okay. Ms. Cross.
Thank you, Your Honor. Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for, that was your personal LLC or PC, your personal legal entity, right? For the
That is
District
correct.
Attorney's Office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. But y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022 prior to you leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all brought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? That was a...
23 is the, I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
$150 an hour.
$150 an hour? All right. So the $150 an hour, the way I understand you all shared profits was you'd get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you
Oh, no, the amount was $65 an hour.
$65 an hour?
Mhm.
All right. That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that's split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were
Minus
asked-
expenses and stuff like that, but yes.
Exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, and I object to it, but I think you might recall the question, that Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about a split among the three of you of about $20 a piece, right, for that particular contract?
For this one, yes,
All right. What about 24? You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's $150.
150 on that one too? All right. And the same sharing went through the business the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes,
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
that is correct.
In 2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances. That you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at that time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I would consider,
It goes to potential bias. Ms. Cross.
would I consider myself a friend of Mr. Wade? I would.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
That is incorrect.
There was not an allegation that you sexually assaulted one of the employees in the firm.
That is incorrect, but yes. Yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, there was an allegation, yes.
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is incorrect as far as what was. No.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you
I never signed any, I never gave any money. I left the money in the escrow account. What happened to that money? I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes.
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention, or why did you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
I didn't hand any money It was money from an escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee. Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
Not two.
To my knowledge, there were not two incidents, no.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her?
I do not recall the name Anna Rodriguez.
From Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this one.
All right, Ms. Cross?
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
All right, at some point, though,
I'm not
It won't-
going to go much further.
okay.
Judge, if this is allowed to continue in this way, it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not...
That's what I was going to do. Don't do that yet.
Mr. Chopra?
Sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although...
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
I'm finished.
Okay. Mr. Sadow.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention these sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney, and the attorney at that time for Mr. Wade, was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his client. Do you mind if I speak? I allowed you to speak.
Mr. Sadow.
Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right, so where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense, but is there anything else, though, that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employee.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel? Okay.
No, Your Honor.
All right. With that understanding, can this witness be excused, Ms. Merchant? All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today. If we
I'm
could.
sorry, Judge, I think I can excuse him. Mr. Sadow had reserved the rest of his cross for after you correct the privileges.
Right. What I'm about to say, just logistically, is what I'm trying to do is, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if, as a result of that in-camera hearing, that I learn that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if upon order of the court, but otherwise, is there anything further the parties need from him today?
Not from him, but I wanted to get those sent.
I know there's other housekeeping things and things we need to do.
And based on the testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have another witness.
I do.
Okay. All right. In that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're going to have to find a time to meet again and go into an in-camera session. Do you understand, sir?
I do.
Okay. All right. Thank you, sir. You can step down. Ms. Chopra, do you have a card for me?
I do, Your Honor.
Okay.
At least I hope I do. I'm the worst lawyer on earth. I usually just tag bus stations with my name.
You can write down your contact information for us?
I will.
All right. Ms. Merchant, do you have any further witnesses?
No, Judge.
Okay.
Your Honor, on the issue of the Bill Solinsky, 1006 versus 611, we're not going to call him. We think the chart, the foundation of the Solinsky chart, is sufficiently in evidence, and we can just use the chart during argument under a 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor. Given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of argument, since I don't know when we're going to be able to have that scheduled. I think this would be Defense Exhibit 28. Let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Sadow.
Your Honor, we are in the process, if the court will allow us, to obtain certain phone records and we'd like the record kept open for the introduction of those photographs. We have them in draft. I say draft, we have them informally, we do not have certification. And they would deal with, remember I asked Mr. Wade about certain activity down in Hapeville during the time period, and it deals with that specific time period. So we're talking about February to March of 2021 to November 1st of 2020.
And is it your intention that you would want to introduce these solely as an exhibit, or you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
I think that we would want to get what we believe is there based on our preliminary research is there. We'd like to reopen and be able to introduce the records and someone to explain what it means. But that's it.
State certainly, I'm sorry, were you finished, Mr. Segal?
I believe so.
All right.
The state would certainly have an objection to that. This hearing has been set. We haven't seen the records, so I don't know if I have any objection to what they are. But the day has been set for quite a while. We object to leaving the evidence open for any purpose.
Okay. And Mr. Segal, when did you first go about trying to obtain these records?
I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship but put parameters on the timing, I sent some subpoenas out in response to that, so that was February 9th. Problem is, Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting, I wanted to remind the court, waiting for those records to be submitted. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If counsel are able to provide those, obviously serve those on opposing counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format, but the exhibits themselves I'm willing to have come into the part of the record, but there will be a cutoff point very soon, as soon as we schedule argument. All right. Any other evidence, Mr. Segal, then?
No, Your Honor.
So that would be cell records. Mr. Stockton, any evidence? All right. Mr. Durham, if you're still with us.
No, Your Honor.
All right. Mr. McDougald?
Certified copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said, was Mr. Gillen's demonstrative, just so I'm keeping it straight.
And so I previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68. 30 is a certified copy of County Code Section 2-69. 31 is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-464. 35 is a certified copy of County Code Section 102-465. 36 is a certified copy of County Code Section 102-466. And 37 is a certified copy of a emergency motion by non-party deponent for protective order filed on behalf of D.A. Willis in the Wade divorce case.
Okay. Okay, Ms. Cross, objection to defense exhibits 32 through 37.
I object to their relevance, and I will take I will take the opposing counsel's representation that the pleading is complete and accurate as it was filed, and object to the relevance of that as well, but not the authentication.
Okay, all right, we'll note the objection for the record, and we'll admit them for whatever weight they're due. So defense exhibits 32 through 37 are admitted. If you could hand those to Madam Court reporter. Any further evidence, Mr. McDougall?
No, Your Honor.
Okay, Mr. Rice.
No, Your Honor.
Mr. Gillen, the demonstrative 38 or 28? Okay, and do you have a physical copy for us already? Great. All right, do we still have Mr. Kucherov with us on Zoom, or anyone else on behalf of Mr. Floyd? So he's not on any longer? All right, I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell.
No evidence, Your Honor.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses? Okay.
The state has 2 short witnesses, and that's it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
Your Honor, these witnesses are going to be
Impeach the testimony of Mr. Dabney?
on a collateral matter. We'll wait and see.
Okay.
Yes, my name is Austin Dabney. That's AUSTINDADNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention, well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2021, 2022. What was your employment at that time?
Yes, I was employed with the Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub, or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
Your Honor, I object to this specific instance of
Sure.
impeachment is improper.
All right, how is this not extrinsic evidence of a collateral matter, Ms. Cross?
Maybe ask a better question. My question will be if this witnessed Mr. Bradley sexually assaulting another employee of the firm.
But same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. Your Honor, the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault. As a witness, I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we've had for the last 2 days.
still object, Your Honor.
Oh, I understand, Mr.
The attempt to impeach Mr. Bradley, they have to live with whatever answer he gave. They can't have a sub-trial with the intrinsic evidence of misconduct here. So we would object.
608. Right? 24-608.
Ms. Cross, under 608, I don't see how this isn't well beyond the core facts of issue. I think you confronted with him. I think he answered them as he saw fit. An argument can be made as a result, but to go down a whole mini-trial on whether he did or did not do this and circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but there was the Wade, Bradley, and Campbell law firm.
And did you work in the law firm office on a daily basis?
I did.
And during the time period, you were there for the remainder of 2001? That is, you worked from March of 2001 at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat the question?
In that time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton?
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job is the first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of? Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that.
At all?
At all.
No further questions?
Any other counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez. Question Mr. Bradley about the sexual assault of Ms. Rodriguez, a client of the firm. He denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter, and so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time, and that would be impeaching of his testimony that he denied.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel, and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation, and to that end, again, using Ms. Merchant as kind of running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment, and if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadal.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
Would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're at a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said. Ms. Merchant. Okay. And like I said, we're gonna follow up with scheduling. Mr. Gowan.
The argument would be on this hearing,
And
also on the forensic.
any other claims brought in any of the filings regarding forensic misconduct, this whole line of questioning? All right. Any other questions from defense counsel? Anything from the state?
We would just ask that we be allowed to submit a brief as it relates to the rulings that you just made, as relates to the objections by defense counsel under 607 and 6021, which is the impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and ask the court to further consider your ruling.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
607 and 621.
Okay, I see 621, I see 608, and
in both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that we conclude this is patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
Okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time a witness denied something, you'd be able to, I think the matter testified to, you'd be able to impeach with extrinsic evidence, and that's, respectfully, that's not.
Well, here's what I'm fine with. Mr. Avati, if you want to submit that brief on purely legal argument, you can, but I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
I believe so, Your Honor, but I'm sorry. They went in the
That's fine. If he is still here, let's relocate to the jury room. Okay. We will be adjourned for today. Thank you all. Miss Taylor, I don't, it logged out on me. Do you think do you think it lost battery, or? I don't need it now. Where are you going to put the
he's never been to. That's one lie you told in your document. No.
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her, so why don't we break that up into smaller parts?
And I didn't ask about living.
But you put in your, while we're talking about professionalism, while we're talking about professionalism, she put in 3 different documents he lived with me.
Full opportunity to respond.
And
filed that with the court.
In 2019.
He's never been to South Fulton. In 2019, I lived in South Fulton. He has never been to my residence in 2019, ever, not once.
In 2019, he's never been to your residence, any place.
I lived in my home in South Fulton before I started getting the threats that were here, a house I paid for with my own sweat and tears. I'm no longer able to live there. But in 2019, I did. And in the 2 months of 2019 that I knew Mr. Wade, 3 months, the beginning of October, all of November, and all of December, Mr. Wade never came to my house in South Fulton. Let me help you out. I lived there in 2020. He never came to my house in 2020, let alone live with me, as you put falsely in these documents. In the first 3 months of 2021, when I could still enjoy my home, Mr. Wade never came to South Fulton, and it is certainly a lie that he lived with me.
So in 2020, so you said 2019, 2020, did Mr. Wade ever visit you at a place that you resided?
He has never been to my home in South Fulton. 2020 was before I knew that a phone call was going to be made and I was going to have to abandon my home. As a result thereof, he never visited, lived at, came to, or has seen South Fulton.
You qualified that with your home in South Fulton.
That's where I lived in 2020.
In 2020, did he ever visit you at a place that you resided?
Okay. I don't understand. You're going to give me guidance. In 2020, I lived in South Fulton.
Okay.
That's the only place I lived in South Fulton. That's before I had to abandon my home, Judge.
All right.
And at my home in South Fulton,
We'll
he never came there, okay? So if you don't come someplace, you can't live there.
Ms. Willis, I'm going to have to caution you. This is going to be the first time I have to caution you. We have to listen to the questions as asked. And if this happens again and again, I'm going to have no choice but to strike your testimony. So, we need to break this down. Ms. Merchant's question, I believe, was asking whether you lived anywhere other than South Fulton.
I did not live anywhere but South Fulton, Georgia in 2020. That is before I began my prosecution of this case, and it was my plan to only live there.
Did Mr. Wade ever visit you at the condo that you leased from Miss Yurdi?
He visited that condo, yes.
He did?
Yes.
Did he ever spend the night at that condo?
No.
Just visited?
Yeah, but he did visit for sure.
Did you ever go out to eat together, other than the lunches you talked about, during 2019 or 2020?
I would think that we probably went to lunch, but it wouldn't have been, let me think, 2019. I'm going to say, I don't know, I'm going to say we probably broke bread someplace in 2019. I don't remember it, but it seems like we would have broke bread sometime in 2019. So I'm going to say yes, although I have no recollection. But it seems to me like I go out to eat and drink with pretty much everyone, so I'm going to say yes.
So outside of the vacations that we've already talked about, did you ever go out to dinner with Mr. Wade?
I mentioned to you that
I'm going to object as to what time period. We're asking very vague questions. I thought we were treating the witness as hostile under 611. We're no longer doing that. So we're going to go back and forth. We need to be more specific with our questions if we're going to treat her as hostile.
All right, Ms. Merchant, it's not so much, I think you can elect between leading and open-ended questions, but I think we are still wondering about, and I think we need to get back on track of focusing on the financial benefit or the relationship.
And my next question about if you did go out to dinner, who paid when you went out to dinner?
He paid, I paid.
You both paid?
Okay, so let me be real clear. We didn't say, oh, the bill is $102. You give $51, I'll give $51. I don't operate like that with my girlfriends. I don't operate like that with anyone. He caught the bill, I caught the bill, whomever.
Did you ever pay him through Cash App?
No.
You only ever paid him through cash?
Well, yes. We're talking about, I'm very confused
You've
now.
never
like-
given Mr. Wade money through Cash App?
No.
The only money you've ever given him outside of a contract is cash?
I didn't give him money in a contract, so that was cute, but I didn't give him money outside in a contract. What happened is, no, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer.
And I will ask you about the contract in a minute. I asked you about cash. Did you ever pay him anything? And I'm trying to qualify my questions. I'm not talking about the contract with Fulton County that was paid. I'm not talking about that. I'm talking about outside of that. Did you ever pay him anything other than cash?
I've only given him cash a few times in the course of what we're talking about.
So you've
if
never
we
used
would
a
go to
credit card?
dinner,
Let her finish her answer.
if we would go to dinner, I wouldn't give him cash because he paid for dinner or I paid for dinner. I've given him cash only a few times in life, probably 4.
Okay.
Probably the most money I've ever handed him is $2,500. The least amount of money I've handed him, probably between $500 and $1,000.
You never wrote him a check?
Ma'am, I don't have checks.
Okay. So you have no proof of any reimbursement for any of these things because it was all cash, right?
The testimony of one witness is enough to prove a fact.
So my
Are you
question was,
telling
do
me
you
that
have
I'm
any
lying to you?
proof?
Is that what you're intimating right here?
I'm asking if you have any proof that you paid him any of these
The
monies.
proof is what I just told you.
You have no written proof. Is that correct?
So I have some, probably some transactions like in Belize. I probably spent $500 on my card in Belize. I spent $900 on each of our tickets to go to Belize. I did the $700. I probably got some minor expenses in Aruba that would be on a card. But for the most part, for those trips, other than, so the 2 cruises, I gave him money for those before we ever left. Because they were pre-booked. Let me answer.
Well, the question was if you had any written proof. And so
I've answered you that I've had written
we
proof.
can move
for
to the next question if you've answered if you had any written proof, and that was my question.
I want to make sure that we're clear that for the 2 cruises,
Judge,
and that's
I
the
asked
cruise
if she gave
plus
him written
Aruba.
proof.
We're not going to talk over each other. Ms. Merchant, she answered your question, so we can ask the next question. Ms. Willis and Ms. Cross will have plenty of opportunities to let you clarify your answers when it's her turn.
Thank you, Judge. Knowing your role as district attorney, you know that public funds are scrutinized and money is scrutinized and things like that. You understand.
I'm sorry, go ahead.
You understand you're under a microscope. You have reporting requirements, all of those types of things. You have no record other than your testimony of the money that you've given Mr. Wade.
You've already asked that question. Let's keep going.
When you took office, you had a tax lien of $4,600. Did you pay that with cash when you made that tax lien whole?
I probably paid through however you pay.
Okay. So, but you were saying that you had amounts of cash. You still had that lien in 2022 when you were dating Wade and going on these trips. So the cash that you gave him, that could have been used to pay this tax lien off?
You gonna tell me how to pay my
I'm going to
bills?
object. This is not relevant as it relates to why we're here today.
Ms. Merchant, are you trying to establish that she was insolvent in some way?
I definitely was trying to establish that she did not have these mass amounts of cash that she's talking about, yes.